The DUI process actually involves two separate things. One is what you typically think of the classic criminal process, where someone's arrested or cited for DUI. They have to appear in court. The court has to decide whether or not to set bail or release them on their promise to come back to court in the future. Then typically what happens is there's another court date, which is essentially a status update to the court, asking the parties what's going on. Are you going to set this matter for trial? Are you in negotiations? And that way the court can keep, abreast on what the status of that particular case is. Now, a lot of times cases are negotiated, and so what will happen is the defense counsel and the client will execute a speedy trial waiver, and under Washington court rule, you have the right to go to trial within 90 days if you're out of custody, or 60 days if you're in custody. But the client can waive that right in order to, obviously, to effectuate need, which is typically getting people interviewed. And most cases don't go to trial within 90 days or 60 days, but they do at times. And so from there, you will have other court dates or a readiness court date, and then ultimately a trial court date if you can't agree on a resolution. And a DUI trial typically is 1 day, sometimes 2, but most often 1 day. And usually you have a prosecutor, defense attorney, the client. You usually have an officer who made the stop, who usually does the entire process, but at times there's a second officer who maybe just did the DUI investigation. There's people from the Washington Toxicology Lab who come in to testify about processes. There's the breath test technician to come in and testify about the machine's reliability. And there may be other witnesses who have made observations, both for the prosecution and for the defense. And that's typically a DUI trial.